So I have always maintained that the legal vacation is anachronistic. It will never make sense. I totally agree with the lawyers who insist they will go to court.
So the Chief Justice didn't single out cases. Let's make this clear. He says, Justice Francis Achibonga, sit as a vacation judge. Here's your warrant. Justice Charity Asem, sit as a vacation judge. Here's your warrant. So it's the judge who has the cases, and then would say that, look, I'm going on with all the cases. Now the impression has been created that the Chief Justice specifically told those judges to sit and deal with only Adu-Boahen and the Hanan cases. That's not correct.
Abusian for Mr. Kwabena Adu-Boahen, the court case here will go so omudi who abansem say me and a lawyer cry friend say Lawyer Atta Kyea or say all court to be because say judicial no echo break no. Lawyer Martin Kpebu, one Mr. Kofi Bentil, or maybe didn't come Eddie Afasa asem no. Now utie in command Mr. Kofi Bentil, oh dear, already or support Lawyer Atta Kyea and asema all can say all court because say judicial no echo break no. Now we sense so I can say Mr. break no crowd or more concept infrastructure in this so. It's about time I was a side no or more ipum. Wakasa bibri wakan say bibu so abe pese me no yeti na asem na all can say bia the Lawyer Atta Kyea all can na ono so odi edi ato no so no ne kwan so ano no and I say they should go and come again. Sanso na Lawyer Martin Kpebu so aba bedi komodi afasa asem kro na ehum o say ohwe Lawyer Atta Kyea the way ya all carries na yes you may have some rights because that has been the norm. Say it may be a judges no obuko break as obuko break in so there are some selected courts omodi omunya setting kra na why enye lucky na se ba bia we di wasem no se judge no wo hon wanko break ni bidia and ye wasem no e wo say ye toa so in the Lawyer Atta Kyea all can say ono the as a bias be na Supreme Court and I say Chief Justice why ye enuntia e ma na asem no ne client na asem no ye di na omodi omunko break no sa asem no o se woni Lawyer Atta Kyea nya adwin sanka baby edi wasem no enka selected course no ho dia eni anka wo liberty wo free say o so betimi akobreak na say ya sarete wo court no and I say wo judge no aka ho no dia you don't have any right say obeka say bia asem no on to aso na say ye free asem na o ma court inti Lawyer Martin Kpebu dia one Lawyer Atta Kyea nya adwin emfasa asem no ho ijakwa say one Kofi Bentil aba be crash we can see we so can see mayen kuri nkotie nsem a Mr. Kofi Bentil one Lawyer Martin Kpebu omo eka na yenso yetumi asua bribi e de afim sa na we so de eye adesua nko na mepese yesua because say eba say court nsensem a menua say woti asem bi na say wo so fa bi etu hufo a eno e na be ma wo so say o nyoma bi na say o ya wo hihie bi a watumi e de wonan asisi yi na wanko ankunya asem to ma chiro mo adwen e de fa sa asem no ho mayen kure nkotie Mr. Kofi Bentil one Lawyer Martin Kpebu we dey mesremo as we be here adwuma kakra bi wa ntima dede kakra bi e wo background no emomofa encheme na ma fasa akonya we so na masrew se wa wo hwem no unya subscribe ya subscribe na e wona ho no na wa kreke so edi amame like video bi na share mo bi no nso unya bi ehwe nyakopo hira na won kan ho yenkotie two lawyers me da wase.
My answer is we don't need 3 months of leave, and some of us worked in other places before we became lawyers. No serious corporate entity allows anyone from chief executive down to take 3 months of leave together. None.
I beg you, let me just add something. Not just let you have. Look, I've worked 1.5 years without going on leave.
Okay.
I tell my minister I want to take some 2 weeks leave. I said, no, Prof. Even 2 weeks, stagger it. Do some 3 days and coming. You are talking about 3 months leave, sailing from here to where?
Your point. Thank you. Let me hear. So back to my point. So in my life as a consultant, we never advise anyone. The rule is this: if anybody can take off from the company for a month together, then they are dispensable. So the normal thing to do is to say, take it in bits and pieces. All right. Yeah. Now we also insist that you take the leave anyway. Right. Because if a company cannot do with any member of its staff, executive or otherwise, taking a leave, then that company is not being well managed. So both ways, if you have to give 3 months of leave, you are not managing well. If you have to give no leave, you are not managing well. If you ask me, do we need 3 months of leave? We don't need 3 months of leave. Next question, do we need to take it together? It doesn't make sense. So I have always maintained that the legal vacation is anachronistic. it will never make sense.
It is just one of those things.
Oh, anachronism. Anachronistic means
antiquated.
I mean, let me explain. It means something which is out of time.
Right.
The time for this is not the time for it. Okay, and I'm saying that because of the history that he's talking about. That in a certain time it made sense. Right now it doesn't make sense. Now there are things that professions arrogate. They have powers they seize. Okay. And doctors, everybody does some of those things, and lawyers in particular, these are gowns and our wigs and whatever it is, we can do it, so we do it. But my worry is where what we do has a serious effect on other people. Just over this week, I had to go into some jail somewhere for somebody who had been thrown there and is on remand. And if you go on this holiday, that person is there, a mother, a nursing mother. Okay. You can choose to make your decisions, but these kinds of effects on other innocent people means that you must relook that decision. So for me, I have always held the position that the legal fraternity needs to take another look at this, not because of us, but because of the effect of our work on others. Then it leads to these absurdities which have brought this discussion on, where you say we are on leave. And by the way, when you say we are on leave, so like you said, I'm supposed to be enjoying my leave. I'm not. I have scheduled other things around it. I have trips, I have conferences, other things. So since you say we are going on leave and the judges are not going to come, my lawyers have also taken their leave, things are slow. I have also scheduled things. When you say that, therefore, and I adjust to it, you can't come back and say you alone come to court. Why? All right, so the whole thing clearly is not making sense, and that's what is causing the problem. So I totally agree with the lawyers who insist they won't go to court. And let me say this for the record: this banter back and forth and that kind of thing. Please, all lawyers know that there are some courts that sit during vacations, but this is something that all maybe the juniors will not know, but every senior lawyer knows. I know. All of us in court. The last time I was in court with another senior lawyer, it happened. The judges during vacation defer to the calendar of the lawyer. Listen, during the regular term, if the judge gives you a date, you take it. You can plead with him, but it has to fit his diary. All right? In other words, the court will determine when you should come back. All right? And I've seen people who said, they said, send your junior, that's why you shouldn't do solo practice. So the court have that right during the regular term. During the vacation term, the judges defer to the calendar of the lawyer. They'll say, will you be available during the vacation? Yes, my lord. No, my lord. When are you likely to be available? My lord, I'm traveling at this time. I'll be back at this time. And during vacation, it is the lawyer's calendar that rules. I've heard people talk about that means that you are handing over the power to the... No. It's because we have set up a system. And because we've set up that system, we have gained the right to adjust to it the way we do. And it's not just a system, there are laws backing it. And there's a long convention backing it. And there's something in law called reasonable expectation. If I have something to do, even from last year, okay, it is reasonable for me to expect that because this vacation is coming, I'll have that freedom. And so I can plan something from way back then. So when the time comes and everybody is going on vacation, you tell me that me alone, I should live my life and then come to court. No. So those who are talking as if a lawyer does not have a right to say I can't go to court.
But from what you are saying,
during vacation, it is wrong. And those who are saying a judge has the control over the time, the judge has that control during the regular time. During the vacation, by law, it is the lawyer's calendar that rules.
Clearly, based on the warrant that we have seen from the Chief Justice, there was communication ahead of time that the cases involving their clients was going to be heard. Were they not attending to court? Would you say it's vacation that is legitimately due them, or delay tactics to, as it were, favor their clients in this particular cause? Because this is not the first time we are having vacation courts, but then again, it is because it's involved these high-profile cases. That's why we are seeing this come up. That some will say. Where does the pendulum swing for you?
Yeah. So, Mr. Okansi, what you've said is an amalgam. You see it, different issues. All of them, there's something to be said for each one. So let's see how much time I can do to explain each briefly. You see, before we come to the law, yes, undoubtedly, generally, and my emphasis is on generally, in the High Court, during vacation, we tend not to do substantive litigation. That's to say, in simple terms, the one you put the witness in the box and then cross-examine. So that part, the plenary hearing, that's been the general practice. You see, you've pulled out one case, that's the Akufo-Addo and Japa case, where lawyer Sorry had to do cross-examination in vacation, right?
Yes, that's true.
It's true, but
that's what you see
I'm painting the general picture so that we understand. But generally, that one was an exception. So it's not as if all over the country during vacation, people were busily doing cross-examination. In the High Court, please, let's be fair, in the High Court, as for the District Court and the Circuit Court, for them year round, they go. Okay, they go on. So cross-examination, once the judge is not on leave. So even for those courts too, the judge takes leave. So when another judge comes to relieve that judge who is on leave, that relieving judge doesn't conduct hearings, plenary hearings involving cross-examination. No, we do the hearings generally that are on paper. That's I say paper trial. So you read what each lawyer is said, the opposing lawyers, etc. Then the judge and also listens to oral argument, but not a witness in the box. So that's the general picture. So because we've been used to it for all these decades, we tend to assume that that is the hard law. You see, so you see where the problem came from. It's because that's generally been it, that, during vacation, the vacation judge usually doesn't do the substantive hearing where the witness will enter the box. We presume that it's a no. Yes, that's a practice. But unfortunately for us, that is not what is in the hard law. You see, so, and it happens every time. You always find that there's a disparity between the hard law and the general practice. It's not new. That's one thing many observers will tell you. There's always a disparity between the law on paper and the law in practice. So this is one of the areas where the law in practice gave us room, okay, or leeway. So we all look forward to the vacation. So here, Kofi Bentil mentioned legitimate expectation. Yes. So over this time, but I'm not saying I'm holding legitimate expectation all through 100%. No, I'm saying at a starting point there's that thing. But the only unfortunate thing is that in this case the hard law doesn't support us. So what I see is that we've been used to that practice where vacation generally we don't do the substantive hearing. But now that the law is being thrown in our face, that's to say that, look, in vacation there will be more trials, because you see, with this, it tells you that for all other vacation judges, now this is going to serve a precedent where the judges will insist that, look, for the substantive cases they have, they want to do hearings, not immediately, but I'm saying begin to set a precedent. Right. So we need a bit of time. So the key thing I'm saying is that this one, we need to negotiate and not fight it as of right, because the hard law doesn't support us. It is a practice which supported us. Some have called it convention. No, you see, when you can use convention as an English word, but not the technical word convention. For us in law, when you say a convention, it's a lot more technical. It's a lot more. So just to make it simple, this one is not a convention. It's a practice that's been going on. So now that the law is being thrown in our face, we need a bit of time to adjust. And then you see more trials during the vacation. But we just hope that it doesn't become so widespread that we cannot rest. That's how come I said, Mr. Counsel, let's repeat this point forcefully. The Chief Justice is not the one to set the date. So because this has been the practice and we are all used to the vacation, and that's how come me talking. You see, I'm not around. Yes, that is a vacation. You go away. You see? So what would happen is that you go before the trial judge and negotiate. In this particular case,
so it's not one that you are of right as a lawyer entitled to.
Very good. Now that the law is being opened, yes, okay. It was a convenience that we're all enjoying. But now that the law is being pulled, you take it slowly, go and negotiate with the judge. Elsewhere, I've said that because the judges are different and the lawyers are different, negotiations take skills, etc. So I would have even preferred that the GJA should redirect their letter to the Association of Magistrates and Judges, or is it Judges and Magistrates, right? So that they can do the negotiations at the high level and get general principles, general points of agreement, so that individual judges can be guided, so that individual lawyers can be guided. It's easier, because now what I mean is that, so you may go into court A and tell the judge that, oh my lord, I'm aware it's vacation. I'm also aware you have the right to go off your hearing, but please, I will agree to work for the next 3 weeks. Let's do as much work as possible. Then the remaining, let's say almost another, call it 6 weeks or so, I want to rest. You say, so the judges will understand, but not every judge will take it that way. Another judge will say, no, I won't. So to prevent many negotiations, etc., our leaders at the Bar Association should rather contact the Magistrates Association and see if they can get a general agreement, which we then can use. Because now that this has been said, look, you can't stop a judge from going on. You can't stop a judge from going on, because the law is that once he sits, and let's make this correction, please. The warrant that the Chief Justice gave, it does not say that here the Adu-Boahen case, here the Hanan Aludiba case. No, it's general that you have to sit during the vacation. So once the judge is working, if you have a case before the judge, ipso facto, it means you have to work. If your witness is in the box, or they are now going to put the witness in the box, it must go on. So the Chief Justice didn't single out cases. Let's make this clear. He says, Justice Francis Achibonga, sit as a vacation judge. Here's your warrant. Justice Charity Asem, sit as a vacation judge. Here's your warrant. So it's the judge who has the cases, and then would say that, look, I'm going on with all the cases. Now the impression has been created that the Chief Justice specifically told those judges to sit and deal with only Adu-Boahen and the Hanan cases. That's not correct.